This is TWiT.
All right, who remembers when the first lawsuit, the first legal scuffle between Apple and Samsung began to take place? Anyone know the year?
Is it 2011?
Very good. Yes, I'll take 2011. Exactly.
Hey.
That's when the lawsuit was filed by Apple, claiming that several of Samsung's phones infringed several of Apple's iPhone patents. So here we are in 2018, and this lawsuit is still an active, viable lawsuit. It has gone all the way to the United States Supreme Court on primarily the issue of damages, how the parties calculated the damages. A jury of 9 people found in the trial, which I think was in 2013, I want to say. I don't know. It was in 2012. Anyway, a jury found that Samsung had infringed several of those patents. And so really everything that has gone on since then has been about what that means and how much Samsung has to pay as the result of the infringement that was found. We're talking, Apple has asked for numbers in the billions. So far, Samsung has paid hundreds of millions. Actually, I'm not sure that, I think they did actually pay the money, even though this is all still underway. The trial that starts next week on Monday in Northern California is about clawing back some of the money that has been paid. And the reason that Samsung gets to have this trial and try and claw some of its money back is the U.S. Supreme Court issued a decision critiquing how the damages were calculated here and kicking it down to the lower courts and saying if what has happened is an infringement of a minor part of a patented device, you can't calculate the damages based on lost sales of the whole device. So that's what this trial is going to be about next week. It will be about the standard that's used for calculating those damages. So it'll be interesting to see, and certainly has broad ramifications across the technology world, how the court comes out and whether this now becomes, going forward, the standard that will apply in other similar cases. The analogies people use are, for example, if you have the patent on a cup holder in a vehicle and someone has that patent, you're found to have infringed on that patent, do you then have to pay them the entire cost of the lost cost of the vehicle as a result of your infringement? Just about everybody hears that one and goes, yeah, no, you don't have to do that. Other analogies would be if you have a patent to an icon that appears on a phone screen and someone is found to have infringed that, or do they then have to pay you for the entire replacement value, lost sale value of the phone? So I'm going to kick this over to you guys. Alex has some experience in the past in the design patent arena. Why don't you tell us, Alex, about your background in that area?
So mine is kind of, from an engineering standpoint, looking at, say, a product that we'd be developing, saying, would this be able to actually be able to brought to market because it in some ways is similar to, X product from X competitor, whether, not by design, but because certain, aspects of the design are obvious to someone who is skilled in the art, and therefore is that patent valid? All those kind of general issues. So not really like, patent litigation or anything like that, but more so from an engineering standpoint of kind of an initial analysis of, is this practical at all to do, or are we setting ourselves up for a failure kind of thing? I think that you mentioned the standard of what's it called to there's a phrase that they use to say the whole manufactured article. What's the phrase I'm looking for?
Matt, do you remember? It's the test that the Supreme Court considered in this case. I can find it in one of our links here. Hang on. Soldier on, Alex, and I'll find the name.
I'll just throw you a curveball there.
No worries. It's in here somewhere. Article of manufacture. There it is.
That's the one. And I just think that this case in particular, as well as some others, really show off, I think, how antiquated the current patent system is. Because I think with how complex these modern products are, if you think of how many parts, including design and then actual component choice and aesthetics and user interface and software and all these other things that are within a single, smartphone today, I think that a single test to determine that article of manufacture just seems too complex and would just lend itself to never-ending litigation, which is really what's happened in this case, I think. And I don't think that this really matches kind of the spirit of the patent system and the ability to make a marketplace of innovative products and things that inventors can protect. It will never cease to amaze me, for example, that Apple got a real patent for a rectangular device with rounded corners and a screen on the front. Which they had for the iPhone. I think that one's since been invalidated, but they did have that at some point. And I really agree with Samsung's point here that I think it's too simplistic to say that if one aspect of the design is infringed, then all of the earnings from the entire resulting product should go to that other party. But then you can see the opposite side of the coin that says perhaps that shape, you could argue, if that was one of the patents at issue here, would they have sold half the products they did without that? And I don't really know how you resolve that question except on a very expensive case-by-case basis. Really. Yeah,
excellent point. Matt, I know you are definitely a patent aficionado. Anything you want to weigh in on here as far as this new trial between Samsung and Apple?
Yeah, I think that Alex did a good job of laying out the basic or like the points of this. And my expertise is not in design patent. It's such a trademarky sort of thing because like Alex said, what you're trying to find on the damages point is, okay, we've said the Supreme Court said you can't just have all the damages, which I think makes sense. If I'm infringing, the average patent, the average phone has 200,000 patents. And so if I infringe one of them, you getting the whole damage seems inequitable. And also, so you take that first, but then you say, what is the value of each patent? And so what you really have to make there is what is the economic decision that the buyer in 2009 through 2011 would have made if the corners wouldn't have been rounded on the Samsung phone? It doesn't matter how many surveys you do or how many a purchasing decision, especially when you're dealing with emerging brands, which really the iPhone and the Samsung was this was the beginning of the smartphone revolution. We were defining what the look and feel of all these were, and to say that it won because of the rounded edges or a certain bevel, that's just a really hard thing to do. It's incredibly difficult to historically track how these individuals would have made their purchasing decision. But ultimately, that's what equity is asking the court to do. Is asking to say, but for this for this design, they would have probably designed something else. They would have had a competitive product, but what percentage would have been less competitive than it was in the market? So this is these kind of cases are litigators' dreams because they're big open questions that you just got to bring a bunch of facts and tell a very compelling argument about.
Right. It seems like Apple has been able to do that before in this case. That's why we find ourselves talking about whether Samsung has to pay hundreds of millions or billions to Apple as a result of this. It really doesn't seem like they're going to be able to make too much headway in that determination that they infringed and owed money. But this question of how much money they owe is a really big question, and could, if Apple gets a real home run here on the damages, that's going to have a real chilling effect equally as much as the fact that they got an infringement verdict to begin with. So definitely one to watch next week. Any final thoughts, Alex?
Not really. I think you guys really hit the nail on the head. One thing that is particularly difficult about this one is that comparing our thoughts on like smartphone design in particular in 2018 to what it was at the time, it's now there's such a commodity item, and it seems so obvious that everything should be this glass 6-inch slab with these different app icons on it, that wasn't obvious at the time, but now we see it so obvious because they're so ubiquitous. So I don't really know how you resolve that to anyone's real satisfaction.
Right.